Number 85, Everhome Mortgage versus Aber.
Good afternoon, Your Honors. May it please the Court, my name is Mikkel Bliss, and I am representing Everhome Mortgage in this appeal. The key issue before the Court today is whether the Appellate Division erred in determining that the information submitted by Equity in support of its motion for summary judgment seeking to dismiss the action was sufficient. We submit that the Court did err. The motion to dismiss was based entirely on an allegation that Everhome had commenced an action in 2009, and that as a result, the current action commenced in 2015 was time-barred. Once that allegation was established, the burden shifted to Everhome to either establish that the action was timely or to raise a question, an issue of fact, as to whether it was timely, which would preclude the granting of the motion to dismiss. Now, this Court held in Freedom Mortgage versus Engel that whether a foreclosure claim is timely cannot be ascertained without an understanding of the parties' respective rights and obligations under the operative contracts, the note and the mortgage. The note holder's ability to foreclose on the property securing the debt depends on the language in these documents.
So what happened here?
So here, we introduced, in opposition to the motion to dismiss, a verified answer from Newcomb Aber, the borrower, and prior owner, who the current owner Equity has stepped into the shoes of, which claimed that the 30-day notice of default was not properly served upon him, and as a result, the 2009, the mortgage was invalidly accelerated for failure to receive that notice.
Did you respond to that defense in the original action?
The original action was actually dismissed.
But did you respond before it was dismissed?
I don't recall. It wasn't adjudicated on the merits. The action was actually dismissed for failure to appear.
By you?
Yes.
And so, unlike the Wells Fargo case and the Everhome decision, there's never a decision by that first mortgage court on whether or not there's a reason to dismiss the case for lack of notice, right? All you have is an affirmative defense. We don't know from what you've submitted whether or not Everhome ever responded to that motion, what proof you put in, whether you attached notices that you actually sent. You didn't file any of that in this action, right? We don't know that.
We did not file any of that in this action.
So what you're asking is the later court essentially to adjudicate the notice issue that you didn't adjudicate in the first foreclosure action.
What we're asking the later court to do is to take judicial notice of the verified answer that was submitted to the court in the 2009 action, which, because it was verified by Mr. Aber, has the same force and effect under CPLR 105U as an affidavit, and he disputes that he received the notice. Now, when we raised this...
Can we take judicial notice of your subsequent filing that attaches the notices? That's in the record of the court.
Any notices, I would submit to the court that first of all, that was raised in our opposition, whether or not the notices were filed. They were not submitted to the court, the trial court, the record before the trial court.
To this court, you mean?
Yes.
To this court?
To this
But not
court.
to the 2009 foreclosure action, right? They were
Right.
submitted there. Yes? Can we take judicial notice of something that was submitted in that proceeding?
You can, and my response to that would be this. Any notice issued on behalf of Everhome that would have been prior to 17 days before the commencement of the foreclosure action, they would have not had authority to issue, because the assignment of mortgage into Everhome was issued 17 days before the 2009 action was commenced. So Everhome would not have had standing to issue
I'm
any
sorry, I
notice.
thought you just told me you didn't know if you filed a response to that defense in the first action.
I wasn't sure if that actually was responded to. I did look up last night that there were notices that were of record.
It seems the way your papers are phrased here, that you know that those notices, as Judge Wilson was saying, were sent by Everhome. So without it saying that you filed them, you're saying, well, if there were notices, they were filed by the wrong company, essentially. right?
If there were notices, they were filed by the wrong company. That issue was not before the trial court, and the trial
didn't
court
ever
itself was
submit it,
confined to the record in determining the motion to dismiss. The point they were trying to make is that on the motion to dismiss in the trial court, the information that was submitted to Judge Deere was not sufficient to warrant dismissal of the action.
I'm a little confused about this. The wrong party is submitting the notices. You were an assignee, right? You step into the shoes of the assigner, or did I misunderstand that in the record?
You step into the shoes of the assigner, but I
So if
don't...
they had issued the notices, you take the case as it stands, no?
If Everhome had authority to issue the notices, it would have accrued once the assignment of mortgage was given to them. Anything prior to that, they wouldn't have had standing to issue the notices. Just as if a lender without an assignment commences a foreclosure action, they don't have standing to bring the action. It's the same proposition. So, with respect to the papers that were submitted to Judge Deere on the motion to dismiss, the only thing that was submitted was an unverified complaint. When we raised the issue of 22B of the mortgage requiring that a contractual notice of default be sent, we also
Was
raised...
there an objection made with, assuming for the sake of arguments that the complaint wasn't verified, was an objection made?
No. So Mr. Aber actually submitted an affidavit in support of the motion to dismiss on reply. There was no response made with respect to verification of the complaint. The submission of the amended answer constituting a judicial admission that he did not receive the default notices was not addressed, and the issue of the assignment of mortgage being given to Everhome only 17 days prior to the commencement of the 2009
He
action.
could have received the notices and they're defective?
I'm sorry, I didn't
He
hear
could have
you.
received the notices and they were defective?
He claimed that he did not receive them,
I
and
know,
as a
but let's
result,
say,
was
let's
not
say that that
validly
is not
accelerated.
what the court finds, but they could have still been defective, right?
They could have been defective.
So the fact of receipt doesn't resolve the issue, correct? Because you agree that under the agreement, the notices have to be effective. They can't be defective notices.
Yes, they have to be effective. They have to provide 30 days of notice to cure, and they have to, and then the borrower has to not respond to the notices, and only until those notices are sent does the right to foreclose accrue.
But I'm saying the notices themselves, let's take one example, the substance of the notice could have been defective. So
Yes.
the fact that they received a defective notice would not have helped, would not have satisfied, the requirement under the agreement, correct?
No, it would not have it. The notices must be accurate.
Okay.
So back to the verification for a moment. Isn't there in the record of the court a verification by Mr. Frank Casara, the attorney, notarized and submitted? Verification of the complaint?
My understanding is that what was submitted to the court
To
was
Judge
an
Deere,
unverified
to
complaint.
Judge Deere.
To Judge Deere, and we pointed out that the complaint that was submitted to Judge Deere was unverified.
But you're not
And it
saying
was not
that-
corrected on
You're not
reply.
saying that the actual complaint filed in 2009 was unverified. You're saying that Judge Deere didn't have in front of him proof that it was verified.
Yes, that's what I'm saying.
Okay. And do you know whether it was verified?
I do not offhand.
Okay. And can we take judicial notice of a complaint that is filed in a court of the state?
Yes, you may.
Okay.
I see that my time is running, so just to sum up, the election to accelerate has to be made in accordance with the note and mortgage. We did not in the trial court need to establish for a fact that the prior action was untimely. What was required was to raise an issue of fact as to
Counsel,
whether or not it
I'm
was
sorry to interrupt
untimely.
you, because I see your time is almost up, but on this verification issue, I thought the argument you made in the trial court was that it wasn't verified with someone with personal knowledge, so therefore it couldn't be used under 3212B. Not that it wasn't sufficient to accelerate the mortgage as an initial complaint, but that your complaint didn't wasn't sufficient or something like that as proof under the summary judgment standard for this action. Right? It wasn't, I don't see anywhere in the record in the trial court where you made the argument that the unverified complaint didn't accelerate the mortgage. And I'm looking at page 115, I think, which is where you really discuss this in the trial court, where you make your argument. And it says that no one has personal knowledge of anything because the affidavit isn't submitted by somebody with personal knowledge. I think that's the argument you're making here.
So to clarify, we made two arguments based on personal knowledge. The affidavit that was submitted by counsel in support of the motion to dismiss was not based on personal knowledge. It was an attorney affirmation that included documentary evidence, but was not based on any personal knowledge. With respect to verification of the complaint, we mentioned that at page 117 of the record, paragraph 99, where we state that insofar as defendant counsel relies on the complaint in the prior foreclosure action to assert that no payment or acknowledgement of the indebtedness has been made, such a basis is insufficient. A review of the complaint in the prior foreclosure action shows that the complaint was not verified. And that
Right, but you
statement was
didn't,
based
you didn't
on...
finish the paragraph. The last sentence is, respectfully, plaintiff's prior counsel would have no personal knowledge on the issue of when defendant Aber defaulted on the subject note or which installment defendant Aber was due for.
Yes.
That's a different argument. I mean, that's not an argument that it didn't accelerate the mortgage foreclosure action. It's an argument that plaintiff's prior counsel had no personal knowledge on the issue of when the defendant defaulted.
Well, the acceleration argument, if I may, rests on whether or not the predicate notice was properly sent, because the right to accelerate the mortgage by virtue of that complaint does not accrue until that notice is sent. And that issue was specifically placed in dispute by Mr. Aber himself. Now, equity would have us disregard that in an attempt to distance themselves from Mr. Aber, but they filed a joint answer in this particular action. So for equity to claim that he's not bound by Newcomb Aber's answer specifically denying receipt of that predicate notice is illogical.
Thank you, Ms. Bliss.
Thank you.
Good afternoon, Your Honors, and may it please the Court. My name is Anthony Filosa of Rosenberg, Fortuna, and Laitman. I represent the respondents. The order of the appellate division should be affirmed because all that this Court's mortgage acceleration jurisprudence requires in order for a lender to exercise an optional acceleration clause is a, quote, unequivocal overt act demanding immediate payment in full. That is exactly what took place here when plaintiff interposed the 2009 complaint and commenced the 2009 foreclosure action. The
But
respondents...
isn't that jurisprudence based on situations where there is not the parties' agreement as to what has to occur before the lender can seek to accelerate? And here the parties entered an agreement saying it's multiple stages. You've got to go through these steps before you can actually seek to accelerate.
Certainly, and I'd like to address the angle language since what Your Honor is getting at. I would submit that it's an oversimplification of this Court's jurisprudence to simply state that if the mortgage contracts require steps A and B to accelerate, and if, say, for instance, step B did not occur, ipso facto, there was no acceleration, without first determining what the legal import, what in the eyes of the law is the missing step. So we must read that angle language in the context of this Court's longstanding contractual condition precedent jurisprudence. So if the missing step is a contractual condition precedent, so here, for the sake of argument, the missing step was the 30-day notice, that's a condition precedent that the lender is obligated to perform. So under our longstanding contract jurisprudence, a party cannot seek to benefit from its own failure to perform a condition precedent. It cannot rely upon or take advantage of its own failure to perform a condition precedent. Likewise, if that condition precedent is for the sole benefit of one party, and here I don't believe there's a credible dispute that a 30-day notice, which essentially gives us more time to pay, is anything but for the benefit of the borrower. Only the borrower can waive or excuse the absence of that condition precedent. And that's exactly what transpired here. I would also just echo, in terms of Angle, I mean, I argued Angle. That Angle language arose in the context, we have to recall, Angle had 4 companion cases.
All right, okay, so they don't benefit from it, I understand your argument on that, but they didn't, right? Because that first action did not result in a foreclosure,
Well,
correct?
they can't benefit by escaping a statute of limitations bar here by pointing to their own failure to serve a notice and saying, oops, well, my prior action really didn't accelerate the the claim, when we have an unequivocal overt demand in a complaint that was verified by the bank's counsel.
So what do we make if that action had been determined favorably to the borrower? That indeed they had not properly complied with all of the steps?
Right.
And then they refile, and now it's outside the statute of limitations. Is the borrower now bound
Well,
by
if
the
I'm
prior
understanding-
decision, or can they make some other argument and say it doesn't matter because they were trying to accelerate, that was their intent?
If I'm understanding Your Honor's question, is the question, had action number 1 been disposed of successfully on Abe's affirmative defense
Correct.
of lack of...
Correct.
Look, I would submit that the failure to satisfy a condition precedent that one party is obligated to perform, they cannot benefit from. So they cannot escape a statute of limitations defense. But relatedly here, I guess
But the
this
statute
is...
of limitations goes to whether or not they accelerated. And if you have a court that says you didn't comply and you didn't, so you were not able to, and this is not a valid acceleration.
Right. But again, dovetailing back to what is an acceleration. Acceleration is an overt demand, unequivocal demand for immediate payment in full. I would submit, again, Your Honor, that's purely a hypothetical. Obviously, that's not our facts here, where there wasn't a judicial invalidation of the election in action number 1. So that dovetails with the Second Department's analysis here, that where we don't have a judicial invalidation, that for that additional reason, a lender cannot utilize court number 2 to invalidate what did or did not take place in action number 1. On the judicial notice front, I think that
So
this...
then where would that leave them then? That they now cannot accelerate, but they can keep asking for the installments? If the time hasn't run out on any particular installment, or what did I miss here?
Well, if the loan was accelerated by action number 1, and our position is it was accelerated by action number
Okay.
1, then the entire debt became immediately due and payable upon the commencement of action number 1.
No, I got that, but let's stay with that original hypothetical I had. What if it had been decided in favor of the borrower?
Right. Well,
What does that mean for them? They can keep asking installment by installment, they just can't then seek the full debt?
I would still submit that, again, the failure of a condition precedent does, in this type of instance, this type of condition precedent, which is really just a procedural prerequisite to suit, doesn't affect the accrual of the cause of action.
But why wouldn't that be Wells Fargo part of Engel, where there was a successful motion below? It was a different motion, it wasn't a notice motion, but the court determined it, and that's it. Now you know you didn't validly accelerate.
Right.
The court's determined that. It's a different case, but why?
Well, again, Wells Fargo v. Verrado failed under this court's unequivocal overt demand test, because if we all recall, Verrado had a situation where a bank was attempting to accelerate instrument 1 by making a demand under instrument 2. So
Right.
logically, you're not,
But the upshot of that was there was no valid acceleration, which would be the upshot of giving no notice.
well, I think the upshot there, I think if we're getting granular, is there was no unequivocal overt demand for immediate payment in full under the instrument. I think the presence or absence of a condition precedent that's inserted solely for the benefit of the borrower doesn't convert a demand and a complaint that's otherwise unequivocal
I think
and
that's hard to
overt.
square with Engel's language that you have to accelerate according to the terms of the mortgage.
Right. But again, I think if we take that to its too far, then how do we reconcile that with this court's contractual condition precedent jurisprudence, which states that, again, a party cannot benefit from its own failure to perform a condition precedent? So then I guess essentially those two rules can't peacefully coexist if we're saying there was no acceleration here, even though there was an overt unequivocal demand for payment under the right instrument, but we, the bank, just failed to perform a condition precedent that we were obligated
Yeah, but
to
that
perform.
condition preceding, like, let's say the case with the 150 feet of waterfront, and
Right.
there's really 130 feet, and, you know, and you get to get the contract because that's the seller's condition. That's a little bit different than you make a motion and knock out a lawsuit based on a failure to give notice, and therefore failure to properly accelerate the debt. That's a little bit different than I still get to buy the land on 130 acres of, you know, waterfront property.
Well, I would still submit both fit this court's definition of what a condition precedent is, and I'm quoting from the IDT Corp. Case from 2009. It essentially adopts, and this court has long adopted, the restatement definition of what a condition precedent is: an act or event other than a lapse of time which, unless the condition is excused, must occur before a duty arises. The operative phrase on this record is, unless the condition is excused. So this court could perhaps leave for another day whether the hypothetical, had there been an invalidation of the notice in action number 1, because that's not our case, focusing strictly on this record, the condition was excused. Mr. Aber took the position in action number 2 that the 09 action triggered the statute of limitations.
So just so I have your position right on Judge Rivera's hypothetical, the loan is not decelerated if your client wins on the condition precedent, right? And, hold on, but then I'm asking, so could the lender the next day send a letter decelerating the loan?
Yes.
Okay.
Yes, because under Angle, yes, provided the act of deacceleration occurs within the 6-year limitations period, then yes, the lender can deaccelerate. I want to close on maybe one point with respect to, well, again, on the allocation of the burden of proof here, I just want to make
Yeah, I
clear.
just, perhaps a misunderstanding. I want to go to this point about they can't benefit from their failure to comply from the condition precedent, but yet you're holding them to an acceleration that you took the position had not validly occurred. So how are you not trying to benefit from?
No, it's not our position
Okay.
that the loan, it's our position
Okay.
that the loan was accelerated with the filing of the 2009 complaint, because that complaint contained an unequivocal overt demand for immediate payment in full.
But that's contrary to the position you took in the action. That's what I'm saying.
Well,
How are you not trying to have it both ways?
Well,
How are you not, to the extent that you're arguing that they are trying to have it both ways,
Right.
right? That's what I understood your argument to be. I'm not clear on how you're not trying to have it both ways. So both sides perhaps a little fast and loose?
well, I would submit that there's no judicial estoppel, if that's what Your Honor is getting at, because again, we didn't prevail in the court below on that affirmative defense, which again, I guess that leads me to
No,
another
I'm
thread.
getting to why not hold both parties to the paragraph, or the paragraphs, because they do cross-reference other paragraphs, so the main one being 22, of course.
Again,
Why not hold you to it?
Again, because here, I guess this is where the validity of no judicial invalidation, because again, had we prevailed, we would be judicially estopped from taking a contrary position. You can't win a case 1, advance that argument successfully, get a court to adopt it, and then take a contrary position and
But we don't know what the outcome would have been,
well,
right?
but again, but that's the essence of the estoppel. That's why there is no estoppel effect as against Mr. Aber here. If I may, on just one point that I wanted to add before I address Justice Rivera's question. There may be a low-hanging fruit here on Hecker v. State. There's an issue of whether a large number of these issues are even reviewable by this court. I mean, this court, I guess, is aware of the context in which this case came before the court. There was a 2-justice partial dissent in the appellate division, so it's appealable as of right. However, I'll submit with all due candor, you'll strain in futility to find the phrase condition precedent solely for the benefit of the borrower, or one party prevailing on its own failure to exercise condition precedent in the lower court record. So those weren't, if they weren't raised before the lower court, and this record appears that they weren't preserved for this court's appellate review. So to the extent that the appellate division based its order on those separate rationales, which it did, it's the primary rationales that the appellate division raised at record 386, that must be deemed an exercise of the appellate division's interest of justice jurisdiction, which this court does not have. So under Hecker v. State, it would seem that there must be an affirmance.
I
because
don't see the appellate division writing exactly that way. It seems to me they say that. They say, they're waivable by the borrower here. But the next paragraph, at least in terms of the 30-day notices, they didn't waive it. They raised it. So the first part, it's interesting, but even if that's so, they didn't waive it here. You raised it as a defense in the first action.
Right, well, I guess if I can read the appellate division's mind, as lawyers are apt to do, they have several alternative grounds for their determination, right? If I'm understanding Your Honor's question, that really boils down to how narrow are we to define, quote, the issue or the rationale for preservation purposes and for Hecker purposes. And I would submit an overly broad definition of, quote, the issue or the argument would arrogate Hecker itself and would essentially have this court creating for itself an interest of justice jurisdiction, which constitutionally it doesn't have, and by statute it doesn't
No, I
have.
understand our jurisdiction, but I just think the issue I have with the appellate division is, in a Hecker context, is they didn't rely on that. I mean, even if you could waive, there was no waiver here. So we can just decide, was it enough in raising it in the answer, the way they have, that you've submitted, was that enough to create an issue of fact? I mean, that seems to me the issue that's before us.
Right. Well, I guess it seems like the primary rationale advanced by the appellate division being that, again, irrespective of whether it was or was not served, if the bank, as the party who had to perform that condition precedent, can't essentially derive a benefit from its own, I believe the court used the term breach, its own breach of a contract. So with that, I'll rest, Your Honors. Thank you.
Thank you, counsel.